Hello everyone, this is Tamara, your courtroom companion. And if you're new to the channel, welcome. I'm glad to have you here. And if you're a faithful follower, welcome back. Glad to have you here as well. This is the channel where we talk about custody, family court, and narcissism. So if those topics are of interest to you, please do keep coming back. And please do hit the like button and the subscribe button when you are here. Thanks so much. In today's video, which is titled How to Testify in Court, I'm going to share with you 5 tips for how you can testify in court. And I'm also going to share with you a personal story. So please do stay till the end because I'm going to share a personal story about how one of those strategies was really instrumental in a recent hearing that I had. So I'll give you a little bit about my own personal story. As always, what I express here is just my own experience, my own personal journey with those 3 topic areas. I'm not a mental health therapist. I'm not an attorney. Just sharing with you things I've learned over my 8-year court battle. If you need support from the professionals, please do go out and get that support. And I have lots of tips on how to select the right folks for you on this channel, so do check out my other videos. And again, please do hit that subscribe button and the bell notification so you'll be notified when I upload my videos. All right, let's just jump right in. So tip number 1 probably seems very basic, but it is really the foundation of what you're gonna do in court when you're testifying, and that is to tell the truth. Your attorney can clean up anything that you say, so just tell the truth. That is your best bet for demonstrating to the judge and to those in the court that you have credibility. You never really know what the other side has in terms of proof or evidence. They're supposed to provide all of that ahead of time, but sometimes things can slip in, so just always tell the truth. That is your best bet for ensuring that you stay out of hot water, you don't perjure yourself, and that you can show the judge that you are extremely credible. Tip number 2 is to look at the judge while you're speaking. That one sounded really strange to me when my attorney told me to do that, because I thought, aren't I supposed to be looking at the attorney who's asking me the question? It seems more natural to do that, but he encouraged me to look at the judge while I'm talking. And at first it felt awkward. It felt like I was doing the wrong thing, but it became like second nature, and I just began to always talk to the judge. This allows the judge to see you, your eyes, and you're like seeing that judge one-on-one. They're seeing your eyes, you're seeing his or her eyes, and it just is a way to demonstrate credibility. They see a lot of people coming through the court and they've probably seen it all, but if you're able to look the judge in the eye, then that, I think, speaks to your credibility, as my attorney suggested. Tip number 3 is not to argue with the opposing attorney or the judge. And in other words, don't have an attitude, don't argue. They're both there to do a job. The other attorney is there to be the advocate for your opposing party, whether that's an ex-spouse or someone else you're against in court. That attorney is there for that person. So naturally, they're going to go after you with all that they have, and they're going to come at you strong and hard. That's their job. Don't take it personally. They're there, they're getting paid to do a job. And so your best bet is to just remain calm and just don't have an attitude, and just don't take it personal. Same with the judge. The judge is there to, manage the courtroom, to sustain objections or to overrule objections. They're there as sort of the manager of the court. If they are asking you questions, and I've seen judges ask questions of the parties themselves. I've been asked by a judge questions that maybe my attorney didn't ask or the other attorney didn't ask. My opposing party was also asked questions by a judge, and you are not to get an attitude or get unprofessional. So just remain professional at all times, regardless of what is being said, regardless if they're trying to character assassinate you, regardless if they're trying to show something that's not true. Your job is just to remain neutral and just to not have an attitude. So definitely take that warning there. Tip number 4 is to only answer what you are being asked. Now, this is the one that I'm going to tell you how this was impactful in my own case in just a few minutes. But if you're asked a yes or no question, you answer a yes or no answer. That's it. You might want to elaborate, but don't. Don't do the job of the other attorney. If the attorney did not ask you to elaborate, don't do his job or her job for them. Just ask, if they ask you a yes or no close-ended question, as they say, you answer with a closed response, yes or no. If they ask you a question that requires a more lengthy response, then answer only what they ask you. It's going to be tempting to elaborate and to explain yourself, but that's not the time to do it. If your attorney or another attorney thinks it's important, they will ask you the question, they will pull it out of you. That's really, really important, because it's natural to want to just keep talking to kind of show your side, but don't do that. Just answer the question as it's asked. That's probably gonna be the most hard. That was the hardest for me. Maybe it will be the hardest for you as well, but just answer what you're asked. Tip number 5 is to briefly pause after you're asked a question. And the reason for that is you have to kind of listen briefly to see if there's an objection on the question. Sometimes there's an objection. There's many reasons why it could be objected to, but some of those reasons might be because it was improperly asked. They didn't do correct form. It could be any number of things, but just briefly pause to hear if there's an objection. And if there's an objection, wait for the judge to rule whether it's sustained or overruled. If the judge sustains the objection, then the person that asked the question, the other attorney, has to rephrase it or ask another question. If they overrule it, your attorney should tell you, go ahead and answer. So just briefly wait to hear whether or not there's an objection, and then wait for the judge to rule on that objection, and then preferably until your attorney tells you what to do, whether they tell you to continue to answer or to not answer the question. Okay, so that's tip number 5. All right, now I want to share with you how tip number 4, which is to only ask, I'm going to go back to what I said, that tip number 4 about answering only what you're asked, and how that was impactful in a very recent hearing that I had. So let me give you the story. So I went to New Orleans on an adult-only trip. So some family members and I went on a trip to New Orleans in early March of 2020. And then I came home, and then COVID hit. So when COVID hit, I withheld access to for physical custody for my son to go over to his dad's. And there were several reasons. One is that he has an underlying health condition, and that, coupled with the fact that I knew that some of his dad's family were still working outside of the home when COVID hit, and they were still, as far as I knew, still actively going to church outside of the home. And so I withheld access, and it was 18 overnights, but that was stretched over, his weekend access. He has every other weekend access. So I withheld that access because of those reasons. So, of course, I knew that when I did that, he was going to file a motion to enforce. I knew that, but it was like, I guess we'll end up in court, because I was more concerned about my son's health than I was about going to court. I just felt like I would have to deal with that at the time. So he did file the motion to enforce, and we didn't go to court until like September of 2020. But before we went to court, right when my state, the governor sort of opened up access at some point, the stay-at-home orders were lightened a little bit. And when that happened, I told, my son's father that he could resume his access, and that I owed him 18 overnights. And I said, why don't you just keep him from now until whenever, just until his 18, whatever his 18 days would have been. I forget, it would have been, we opened up our county sometime like in May of 2020, and whatever day it was, I counted out the days, and I said, why don't you just bring him back? I think it was like June 5th or something. These dates might be a little off, but in other words, here's the time back. Why don't you take it and then just return it to me, whatever the date that was. He said no. He said the court will decide how he gets his time back, and he wanted to go to court. Okay. that was it. So he didn't get his 18 overnights back. He just resumed his regular every other weekend access. So then we went to court in September, I believe it was, of 2020. And his attorney came in and he was firing all kinds of questions at me, and he was asking me yes or no questions. But it was really, really hard for me to answer just yes or no because I wanted to defend myself. And here was the line of questioning. And you can kind of see where he's going with this. So he's asking me, did I go to New Orleans during Mardi Gras? My answer was no. Did you self-quarantine when you came back from New Orleans? My answer was no. He asked me if I wore a mask on the plane to and from New Orleans. No. Did you obey the signage while in New Orleans? And I couldn't answer that question because at the time there was no signage because I went before COVID hit. So I had to wait until the objection came from my attorney because it was an improper form. It assumes facts not in evidence. There was no evidence to show that there was signage. So I kind of knew, being in this for 8 years, I knew that there would be an objection on the form of that question. So I waited for the objection and, went on from there. So anyway, that was the kind of line of questioning that his attorney was asking me. And it was really hard to say, no, I didn't go during Mardi Gras. I was there after Mardi Gras and before COVID. It was hard for me not to say that, but he asked me a yes or no question and I answered yes or no, whatever the question was. And it was hard for me to say when he asked me if I wore a mask on the plane. It was hard for me to say no because it wasn't required. That's not what he asked me. He asked me a yes or no question and I had to answer yes or no. Now, all this time that I think he thought he had some kind of smoking gun by this line of questioning. He went at me full force, but again, I stayed calm. I just answered his questions. I didn't have an attitude. But I knew, because I had prepared with my attorney, that we had proof of when COVID hit New Orleans. So I knew that my attorney, when he got up to question me, I was going to be able to show that I didn't need to wear a mask, that I didn't need to self-quarantine, I didn't need to do all the things that this other attorney was going after me for. So when my attorney got up, he asked me when I went to New Orleans, and I explained. He asked me why I didn't wear a mask, on the plane and while I was there. He asked me if there was any signage in the airports. He asked me all the questions to clean up what the other attorney was trying to show. But when he pulled out the proof to show that New Orleans' first case of COVID was when I returned back home, it was after I returned back home. That's when the first case was reported. And if you all know, COVID hit the States overnight. Within a week, everything was shut down and it happened so quickly. So when I came back from New Orleans, that's when COVID became a thing. As it turns out, the judge did not award him his 18 days. And the reason she didn't award him the 18 days is for a couple of reasons. But one of the main ones was because he should have tried to counter offer. If he didn't like the way that I was offering the 18 days back, he could have said, no, I don't want them all in a row. I want them this way or that way. But he didn't do that. So she didn't award him that, along with a few other things. She did not award him the 18 days. Anyway, I just thought you'd like to hear the ending of the story, even though that's not important for the point of this video. I didn't want to carry tell you all about the story and not tell you the ending. But my point of sharing that story is to share just some ways that those tips came into play for me. Especially that number 4, where you just have to answer what you're being asked. That is the best thing that you can do. Okay, I hope those tips were helpful, and I hope that application in my own life of those tips were helpful to you. If you have other strategies for testifying in court, please do leave them in the comments below. Our community likes to learn from each other, and we'd like to hear from others about what things are helpful to you. Okay, until next time, I'll see you. Bye-bye.